cases for review in today's public hearing. I would ask at this time everyone please silence or put their cell phones on vibrate so as not to disrupt today's meeting. We would appreciate it. The procedure will be to introduce the case record has it. The case record as the Code Department has it, and we'll present any maps, slides, sketches, and photographs on the wall here by means of a PowerPoint presentation. We'll present any letters that we've received in support or opposition to a particular case, as well as any correspondence we've received from other Metro agencies. At the conclusion of our record, the applicant will come first and present their testimony along with any persons in support for a case. Then after the applicant has given their presentation, if there's opposition present, we'll hear from the opposition after that. After the opposition has presented their testimony, the applicant will have a period for rebuttal. The board in their rules provide applicants in cases without opposition 10 minutes to present their testimony. To the right of you where you'll be sitting here at the table is a clock where you can keep track of that. In cases with opposition, the board provides 15 minutes for each side. So 15 minutes for the applicant presenting the case and 15 minutes in total for the opposition to use time for testimony. Those times are total and not per speaker. I do see the elected official here, Councilman Stanley, you are not subject to those time constraints. So if the applicant wishes to have a rebuttal period, they'll need to save some of their 15 minutes they've been allotted. All section numbers that I refer to today come directly from the Metropolitan Code of Law. Title 17 was adopted by the Metro Council on January and became effective January 1st, 1998, and applies to the entire jurisdiction of the Metro government. I'll introduce and make a part of the record the zoning code and will dispense from reading individual sections of the code unless an applicant or opposition requests that I read those sections. The code requires that these proceedings be taped. Therefore, it's imperative anyone wishing to address this board to come forward. You'll have a microphone stand very similar to mine. Two buttons on that. The button on the right is the speak button. Once you hit that button, the ring on the microphone will be red, or your mic is hot, and present your testimony to the board. When you get done, please, if you'll turn that, press the button again, and that'll help us with the audio here in the room. The board will go through all cases set for public hearing today, and after each case, the board will discuss and vote on that case. The board's vested with the power to act on the cases as outlined in Section 1740-180 of the Metro Code. The code requires that 4 members of this 7-member board be present to constitute a quorum. The code also requires that you have 4 affirmative votes to grant your application. In the event, as we currently have only 4 members present, you must have all 4 members vote for approval for your request to be granted. If by chance one of the members does not vote for approval, your case is automatically rescheduled for the next available public hearing. And let's see, that is the second meeting in December. That is the third Thursday of December. I believe that's the 20th, December 20th. So in the event we had a tie vote, that's what we call a tie vote, and you don't have all 4 votes, we'll automatically reschedule you. No additional fees are required by you. The Codes Department will handle the public hearing mail-outs and such. In the event that we have 5 members present and you fail to receive 4 affirmative votes, the case will stay on our agenda for the next 30 days. At the next meeting, the 5 members who participated are eligible to change their votes. The 2 that did not hear it are able to review the record today by means of Channel 3's tape, go over the folder or any documents submitted in today's case, and then become eligible to participate, at which time they could vote. In the event that you have 5 or more members that hear your case and you fail to get 4 votes within that 30 days, your case is deemed denied by operation of law. Any applicant or aggrieved property owner may request a rehearing within 60 days of today's public hearing. Further, any applicant or aggrieved property owner may appeal this board's decision to Chancery or Circuit Court within the same 60-day period. After that time's elapsed, the board's decision is final and no further action may be taken. If you're an applicant and your case is granted, it is necessary for you to come and pick up the permit for which you've applied. Should be noted you have 2 years to pick up your permit after today's agenda for this approval to remain valid. So if you are approved today and for some reason you're not able to construct or do what you've applied for, and you come in 2.5 years from now, you'll have to reapply to this board and seek approval. Mr. Chairman, I submit that all cases were filed in proper order. Appellants were notified by certified mail as required by the code. A legal ad was published in the Tennessean as required by the code, and all affected property owners were sent first-class mail within 300 feet of the subject properties today. Before we begin, the board does allow for elected officials to address the board should they wish to. Are there any other elected officials besides Councilman Stanley present with us today? Okay, Mr. Councilman, would you like to address the board now? Wait till the case. Okay, which case are you here for, sir? Okay, last case on the agenda. All right. Preliminary announcements today. I have one. You do not have it on your agenda. As we have a request for rehearing that has been turned in to the board late yesterday afternoon. I'll pass that in front of you if you don't already have it. We'll take up that case at the end of our regular business today. Also note for you at the bottom of our agenda today are the adoption of rules and procedures for the board. Haven't heard anything from you guys, so I assume we're okay. We'll let you talk about it if there's anything you'd like to change. If not, we'll go ahead and adopt those today. With that, the board does have a consent agenda. A board member reviews the record in each case prior to the hearing, and if in their opinion the applicant meets the criteria for the variance or special exception that they've requested, and if they feel that testimony in the case would not alter material facts, they recommend the case to the remainder of the board for approval. We'll now enter into the record those cases that have recommended for consent by the chair, Chris Whitson. And if there's anyone here in opposition to a case, the number that I call, if you would please raise your hand, and we'll remove that case from consent and hear it in regular order. Just want to back up. One thing I was talking about, we have 5 members present now, so the vote totals that I went over about having to have 4 affirmative votes are still there on that. So the first case recommended for the consent agenda is case 2012-103, Mr. Michael Hammond, the appellant and owner of the property at 2115 15th Avenue South. Is there anyone here in opposition to case 103 on 15th Avenue? Last call. Seeing none. This is a request for a street setback for a front porch, and in item D, what we have here is a legally non-conforming 2-family dwelling that sits approximately 6 feet from the road. The request is to remove that structure, replace it with a new duplex sitting 14 feet from the road. The exceptional shallowness is the hardship listed as a need for a variance on that request. With that, Mr. Whitson recommends that case for consent. The next case recommended for consent is case 2012-104, Cliffs Plumbing, the appellant, JMPD Homes, LLC, at 1805 6th Avenue North, requesting a variance and side setback to construct a new single-family residence. Is there anyone here in opposition to case 104 on 6th Avenue North? Mr. Chairman, seeing none, the exceptional narrowness of this lot necessitates a need for variance in this case. That case is recommended for consent. The next case recommended for consent is case 2012-105, Cliffs Plumbing, again the appellant, JMPD Homes, LLC, owner of the property located at 604 Hume Street, requesting a variance and side setbacks to construct a new single-family residence. Is there anyone here in opposition to case 105, 604 Hume Street? Mr. Chairman, seeing none, this is the exceptional narrowness here is also the hardship needed and necessitates a need for variance in this case. Next case recommended for consent, case 2012-106, Cliffs Plumbing, appellant JMPD Homes LLC, for owner of the property located also at 604 Hume Street. It's actually 604 and a half Hume Street. These are adjoining parcels, requesting a variance and side setback to construct a new single-family residence. Is there anyone here in opposition to case 106 at 604 and a half Hume? Seeing none, the exceptional narrowness of the lot necessitates a need for variance in this case. Last case recommended for consent, case 2012-107, Craighead Development, 817 Benton Avenue, requesting a variance and street setback in R8 to construct a new duplex. Is there anyone here in opposition to case 107? Or question?
As an interested party,
okay.
I don't know what they're asking for. I am the adjacent house.
Okay, I'm happy to. The appellants are here. If you all would please get together, and what we'll do is that case would I'm a little bit premature. If they approve the rest of the consent agenda, will be heard first. We'll just heal that and give you time to talk about that case. Are there any other folks here that have questions or concerns or opposition to case 107? Okay. We'll pull that case from consent, and I'll check back with those parties to see. Those are the cases recommended for consent, cases 103, 104, 105, 106, recommended for consent. And guys, if I could get y'all please to step out. Thank you.
Okay, so we have a motion for consent. Is there a second?
Second.
Okay, we've got a motion, a second. All in favor?
Aye.
Any opposed? Passes.
Should we go ahead and move the only other one we have to the bottom of the?
Sure.
Is that right? We only have one left besides.
Right,
107.
we were going to heal that and hear the Lebanon Pike case.
Yes. So I think we're on to 108.
Oh, so Joey, make the announcement about
I will.
people.
If you're here for cases 103, 104, 105, 106, your cases have been granted. You're free to go. Case 107, we are going to hear that case at the end of today's agenda to allow the parties to speak. And at this time, we'll call case 108 to the table. Are the applicants present for case 2012-108, W.R. Newman, appellant, McDonald's Corporation, the owner. And Councilman, would you like to address the board at the beginning, at the middle? Where would you like to? Okay, no problem. Are there any parties here in opposition to case 108 present? Okay, Mr. Chairman, seeing none. Guys, you'll have 10 minutes to present. Let me cue up the photographs and we'll go over the case here. Mr. Chairman, for the record, we have received one letter in opposition to the request here at case 2012-108. Okay, looks like the appeal is queued up. The subject property, let me recap. This is a variance request in the sidewalk requirements in the CS district to allow for the legal use of McDonald's restaurant permitted under 2010-42727 without the required sidewalks on Bonnebrook Drive. The applicant is proposing to construct the sidewalks on Lebanon Pike. This structure is currently under construction. This appeal was filed seeking relief from the sidewalk requirements in the CS along Bonnebrook. That's the parcel, the area which you see where my cursor is. This aerial photograph is actually of the old McDonald's that sat on the site. That building has been raised. The building itself came before this board, I believe, and what the variances were escaped me at the time. Yes, it was parking and the bypass drive lane. I do recall that. So this is the subject site, Lebanon Pike, running southwest to northeast, Bonnebrook, and the variance request will be along these portions of Bonnebrook. This site plan, to orient you, Lebanon Pike is at the bottom of the site plan. Bonnebrook running on the left-hand side of the page. Sidewalks exist currently on Lebanon Pike and will be constructed around this radius. The portion of the variance request is located in this area on the site plan.
We've got some.
She's okay with it. She understands.
Just in the interest of time for the developers as well, should we just go ahead and consent this now?
Let's temporarily put case 108 on hold, and case 107 is recommended for consent due to the irregular shape and shallowness of the lot by Mr. Whitney.
And I'll second that from Chris.
Okay, we've got a motion, got a second, all in favor? Any opposed? Passes.
Okay. Case 107 is adopted on a vote of 5 and 0. All right. Back to case 108. The variance request will be along Bonnebrook Drive, which is on the left-hand side of the site plan, which you see here. This is looking at the subject property upon my visit there. The bottom right photograph is from Lebanon Pike. Looking into the site, you see the McDonald's under construction there. This is the ramp This photograph is taken from the ramp in which you see here, and I'm looking across the site to the, I guess it'd be the upper right or northeast in this photo, in this site plan. And then views along this, the area here. Upper left, beginning first, this is Lebanon Pike looking south across Lebanon Road. This radius, which you see here, is Bonner Brook, where it turns into and runs northward, going now to the bottom right photograph, looking north along Bonner Brook. This is where the sidewalks are required to be constructed along this area, which you see here, and again in this area. And those are probably the most important photographs that I have dealing with today's case. And with that, I'll turn it over to the appellants. And guys, if you would please identify yourselves and make your presentation to the board.
My name is Ken Crowder. I'm with T-Square Engineering, and I'm representing McDonald's in the request for this variance.
Mr. Crowder, go ahead and pull that microphone right there close to you.
Is that better? McDonald's would respectfully request the variance for the installation of this sidewalk along that portion of Bonner Brook due to the steepness of the slope and the adjacent grades, the steepness of those. It pretty much, I mean, that Bonner Brook is a road that's at 8.49%, and to get the sidewalk in there, you would have 8.49% coming down the slope to Lebanon Pike. And then with the installation of the sidewalk, even if you put it adjacent to the back of curb, the slopes going down into the McDonald's side are going to be 2 to 1, which, you know, if you have anybody walking and they stumble, they're going to be down at the bottom of the hill into the McDonald's lot if we're not careful. So we feel like it's a safety issue and then a slope issue.
Have you seen, we received from Public Works that they have approved they've approved a construction plan permit to allow either a handrail or kind of a guardrail. Did y'all submit that plan, and are you accepting of it? I mean,
Yes, sir. We submitted that plan. It was, I think when permitting was being done, the original plan showed no sidewalks along Bonner Brook. And during the permitting process, Public Works came back and said that it was a requirement for us to put sidewalks along there. So the sidewalks were shown during the permitting to get permitting done, knowing that we felt that it was not a safe portion to put sidewalk on. So yes, the plans did get drawn that way, and they were shown that way. Yes, sir.
well, are you still willing to build it in accordance with that plan?
Well, McDonald's would request that we don't do it. I mean, it was not in the original plan to do, and we had, during permitting, I had one department telling me it was required, and then another department telling me that due to the grades that it wasn't required, that it shouldn't be required. So, we drew the plan to accommodate the Public Works and to show it, and we haven't had discussions with Public Works because they actually wanted a 4-foot grass space before you put the sidewalk, and so that was one of the issues that we discussed, and they allowed us to move it to the back of curb, which is not really not the way they want it done. So it was drawn that way, yes, sir, and shown that way, knowing that we didn't really agree with it because of the steepness of the slopes there adjacent to the sidewalk.
We have the councilman from the Hermitage area here, Councilman Stanley. I'm assuming you're here. Are you here in support of this? You are. You don't have any objections or questions about it? Thank you.
Can I make another point just real quick, if it's okay?
Sure, absolutely.
If you go to the back of the lot, up Bonner Brook, kind of where that sawhorse sits, McDonald's is in the process of putting a retaining wall in along the back of the property due to the depth of the grades there. And at that back point, you're probably 15 to 18 foot. So a sidewalk adjacent to that's going to put, somebody right at that point where that wall is, which, we feel is a safety hazard too, even though we are putting a fence at the top of the wall. It's just a big drop there. Thank you.
So how are you on parking? Are you at your parking limit, or are you over your parking limit?
No, sir. We had a variance for the parking.
On this particular
Yes, sir, we did.
incarnation?
Because the site is such a small site, I think we were required to have, from what I remember, maybe 41 spaces, and this site has, I believe, 32.
I'm sorry, I should know this. Is there opposition present, or?
There's none.
There's none present, okay. Do we have any other questions for the applicant? Okay, then I guess I'd like to hear from the councilman if he would like to speak. Would you like to speak?
Councilman, thanks for coming.
Thank you for having me here at this time. I'll just mention to you that this McDonald's restaurant has been operating at this site, this specific site at Bonnebrook and Lebanon Road for over 40 years. And there has been no requirement of sidewalks up Bonnebrook. I think it's important also to understand that the Lebanon Pike is a state thoroughfare. Overwhelmingly, this section of Lebanon Pike is retail, commercial in nature. But directly behind it, Bonnebrook Drive is a residential artery. And directly behind this McDonald's is a residential district, probably one of the biggest in Davidson County. It's Hermitage Hills, Stones River Estates. It has 1,375 homes on about 420 acres. And I have heard from none of these residents, homeowners back behind McDonald's that are in opposition to this variance in any way. I think it's important to understand that because there is a large residential district directly behind this McDonald's and other commercial operations on Lebanon Pike, there is a clear distinction between these residents and these commercial operations. And I think by allowing this sidewalk, you're going to intrude into that distinction between the residential district and the commercial operations. I did have a community meeting in 1998 with the residents of Hermitage Hills, and I wanted to know if they wanted, at that time I had money in the District 14 infrastructure program. I wanted to know if Bonnebrook Drive wanted sidewalks from Lebanon Pike all the way back to Hermitage Elementary School. And the residents were overwhelmingly in opposition to any sidewalks. And over 40 years, the residents have accessed this McDonald's McDonald's restaurant. And whenever they have, they've walked or they've driven down these small residential arteries. And they want to keep this Hermitage Hills, Stones River Estates area as residential as possible. They do not want to have any sidewalks up Bonnebrook Drive. Bonnebrook Drive is narrow. It has hardly any shoulders to it. I think it's important that we maintain the integrity of this neighborhood as well as maintain the integrity of McDonald's Corporation that's operated at this site for over 40 years.
So this would be kind of like rather like a sidewalk to nowhere then, wouldn't it be?
Yes, I think it would be. Yes, the individuals, the resident homeowners that have spoken to me, they've mentioned to me that they like to walk down their street to McDonald's or to any other operations, commercial operations on Lebanon Pike. Now, there are sidewalks on Lebanon Pike, but that's a state thoroughfare. That's a state thoroughfare that's commercial in nature. And I think it's important to have sidewalks there. But on this residential street, I don't think it's important to have sidewalks. It's necessary to have sidewalks. I will say that right east of this site is Hickory Hill Lane that intersects Lebanon Pike. It's part of this district, residential district. And there are commercial operations on either side of Hickory Hill Lane, but there are no sidewalks going up Hickory Hill Lane. So I don't see any reason why these sidewalks need to be extended up Bonner Brook. I'd like to support this variance, and the people I've spoken with or that have spoken to me have voiced their support for this variance as well.
Councilman, why not have McDonald's pay into the sidewalk fund for this amount of sidewalks so that some other district that isn't fortunate enough to have a McDonald's making all this money for 40 years build their sidewalk? And it's not that long. I mean, what are we talking about? 60 feet, 70 feet?
Well, it's on an extreme slope. And if indeed there are other districts that desire sidewalks to support residential operation in their district, I think it's not the responsibility of District 14 residents, because they're the tax-paying citizens of this city. And I think it's important that we realize that this sidewalk fund that you're speaking of is the responsibility of Public Works.
But this is how it's funded, is it not? Because essentially what they're asking us to do is not only grant the variance to not have the sidewalk, but by default not have to pay into the fund, the in lieu of fund. So, I mean, I guess what I'm asking, you're also in favor of them not having to support the sidewalk fund?
Well, if indeed there is a payment that's required of this restaurant chain to pay into the fund, they will definitely pay into that fund.
Well, I mean, the way the code is, they can build the sidewalk, pay into the fund, or ask for variance, and the variance allows them to do neither, pay nor build the sidewalk.
Well, I just know that the sidewalk is not necessarily viewed as beneficial to the residential district directly behind it, Hermitage Hills. And I think it's important to consider the impact that such a sidewalk will have on the residential district directly behind it.
Thank you.
Do we have any other questions? Any other questions? Okay, then I might close the public hearing.
Let me be clear on one thing. So the sidewalk will turn the corner. It's only the straight part going back.
Yes, sir. It'll go around the radius return and come onto the ingress-egress point there on Bonner Brook. Yes, sir.
Kind of at the edge of the driveway?
Yes, sir. On the south side of the driveway. Yes, sir.
Okay, unless we have any other questions, close the public hearing and discussion.
Close public hearing, case 108.
I will say I am a little bit surprised by the councilman's answer, or the neighbor's answer. I guess it's better because he's representing the neighbors. I would have thought they wanted a sidewalk to walk on instead of the street. But I am more than willing to defer to the councilman and his judgment on his district, and I'm pretty darn sure there's a topographical issue, and I actually do think it would be dangerous if there wasn't some type of railing. So those are my thoughts. I'm not sure if anybody else.
Yeah, I can see that. But I have a question, Joey. You you were talking about the need for the variances when they tore down the existing McDonald's and are building a new one, then they have to come up to the codes. If we grant this variance, then if, say, 10, 15, 20 years from now, this current McDonald's outlives its useful life and is torn down for the next prototype, they would have to come back for a variance if the codes required them for a sidewalk.
They would not. The variance actually runs with the land unless you condition upon this appellant or this use on the property only. You could make a condition that it's for this use. If you get into use, I wouldn't necessarily get to a tenant, McDonald's versus Taco Bell versus.
Right.
But if you condition upon a restaurant use on the property, meaning if they tore the building down and built a retail center, then they would have to put in sidewalks. But minus that condition, the variance runs with the land.
Okay, and then, on the sidewalk, I'd like some clarification too, just so I understand the whole. I thought I'd heard when we were talking about the sidewalk fund in the past that we didn't have an authority to require payment, but is there a path by which they could opt out of this sidewalk and grant, have the, I guess what David Harper was saying, can they basically do what they want to do and pay money and not come to us? Or
Let's ask our lawyer, John Michael, about that. I'm sure if
I
people...
don't understand why I know the issue keeps coming up and I don't understand.
My understanding, it is kind of an either or. Is that correct?
We can't directly pin it in here is about the most succinct way I would say is we can't have this direct correlation of, well, in lieu of doing this, you will then, where it's an automatic connection by the BZA in here. That is a fund that is used sometimes by Metro through the development process in conjunction with any number of departments, whether it be codes and zoning, whether it be planning, whether it be public works, when you're trying to work out some of the nuances of developments like these. But to the most direct point of your question, what can we do in here? We can't really connect those dots.
Well, yeah, that's what I'm really asking. If we give them the variance not to build a sidewalk, it's over. They don't have to do anything else.
Let me think through that. I think that's correct. I want to make sure I followed your question, but I believe that's correct.
They don't have to, build a sidewalk now because we gave them the variance not to do that, and they don't have to pay in the fund once
that's also correct.
Yes, that's what I'm asking.
But,
yeah.
And maybe I misunderstood, but what I had heard through the conversation earlier, and and I think even in previous conversations, was that is there a path for getting your use and occupancy permit, meaning you've passed all your codes, where they don't have to put in the sidewalk, pay to the fund, and don't get our approval? I mean, there is, and I've represented clients in this route in the past, not in front of here, but what happens is your client just decides, I could either build a sidewalk or I could pay in the fund. So they could have just decided to pay in the fund and they wouldn't be in front of us, correct?
It's entirely possible.
It's their choice. They could have either built a sidewalk, they could have paid into the fund, or they could come here. There are three choices. They decided to come here.
And conversely, if we don't approve, they can still pay into the fund and not build it. We're not mandating that they build it if we vote against the variance.
And just
Is that correct?
Again, for my,
their options are still open.
And
that's my understanding, and that may be a better question for the administrators here, Mr. Hargis and Mr. Herbert, because they see that process on the back end once we leave the pool. But that is my understanding.
And Joey, walk us through why we're here for the folks at home on Channel 3. That this is a McDonald's that had been there for 40 years, and now they're doing this remodel project. What has triggered to cause this?
The trigger mechanism here, and the gentleman testified to, one department said you didn't have to, and the other did. And the part that said you did was our department. Once the building was destroyed and taken down, from the zoning code standpoint, all other code provisions are now applicable to this site. Whereas when that business operated before, it didn't have to have sidewalks.
So when this building was originally built, there wasn't a sidewalk
Correct.
requirement. Now for new construction, there is.
Right.
So since they tore it down, took it down, this kicks in the new zoning.
Yes, and the options, the reason they come through this option, and this is your function, is that if you deem a hardship here forget, you all really need to consider this. Is there a hardship here? And set aside, hey, they can go pay in the bank. Because that I think you're getting into arbitrariness there of saying, if we don't grant the variance, we could grant this. But to grant a variance, like any variance, you've got to find some physical hardship with the folks. And that's some of the consultations our office has with applicants before they come and file. If it looks to us as though the site is,
And I think this is a classic example of it's very hard, or if not engineerily, probably impossible to build a sidewalk given the steep pitch of that, very similar to the Bordeaux Y case. And so I think that's the reason why they're here too.
Okay, hearing no more discussion, I am going to move, I'm not going to move that. I am going to move that the board approve the variance because all the requirements of MCL 17.40.370 have been met, and the board finds that the unique characteristics of the property are extreme topography going downward to a dangerous level. So I would say we approve the variance. There's a motion. Is there a second?
I'll second it.
Got a motion, got a second. All in favor?
Aye.
All opposed? Okay, got one opposed. 4 for, 1 against.
Congratulations. Thank you for your time. All right, Mr. Chairman, 2 other items. These are under other business, and the first one we'll take, if I can find, it'll hit me 1 second. Turned off my video. Come up here, that way I can face you. Under our rules, and we're not talking about the adoption of the rules, but under our current rules, applicants can apply for rehearing requests up to even before we start here at 1 o'clock. And when we receive those, we date stamp them like we've received this one and bring it to the next hearing. The request for rehearing is not something by ordinance we have to advertise, but it does have to be in public as we're doing now. But we've received a request for rehearing for a case that we heard last time, case 2012-102, Mr. Mark Harbin, and on behalf of Music City Waste, requesting a rehearing. You have his letter before you. Rehearing request for members, Mr. Taylor, I don't know that you've had one yet. The letter before you and any evidence submitted speaks on its own. So no parties could come and make their case on why you should request or why you should either grant or deny a rehearing. But this letter in and of itself speaks to it. The weight under our or the test that you balance is whether the evidence provided is new evidence and could not have reasonably been submitted before this board at the hearing. So it's not I forgot to say that, but it's new evidence that they couldn't have reasonably have before you. And I'm going to let you read the letter in that's been presented here, and the evidence submitted, whether you find there's sufficient evidence to grant a rehearing. If you vote to grant a rehearing, we will schedule it for the next available hearing, which would be, I believe it would be December the 6th is where we're at. If you turn it down, I'll enter an order appropriately to do that. And then after we're done with that, we need to adopt our rules.
Okay, well, discussion. I would very much like to see us rehear this case because I found this case very troublesome at the time because there were not residences next to it. It's definitely a city need. And to find out after the hearing that the planning department is looking at going through the rezoning process to make it not residential, to me, is very compelling. So I would hope that we would rehear the case.
I'd agree.
Could, which case is this?
This is the recycling, the indoor recycling, C&D recycling off of Murfreesboro Road.
It was going to be, okay.
They were next to TPS.
Right.
Okay.
What, do we know what the evidence is?
Well, it's this email. I
New
mean,
zoning.
The planning department is unilaterally taking upon itself to maybe rezone the property and make it where it's not residential, which means they never even would have had to come in front.
Well, there was one other variance, wasn't, Joey, wasn't there one other variance besides?
The variances were both a function of the residential property.
Oh, really? Both of them were? So, okay. So if-
Well, the other variance was the landscape buffer.
the buffer, okay.
Well, did we vote?
Yes, no, we voted.
So we did vote. This wasn't one that was
Yeah, to
suspended.
No, but
recap.
as Joey said, they have an option to ask for a rehearing within
Yeah,
a certain amount of time. And
I'm getting my C and D variances mixed up, so I was trying to remember which.
Let me recap for you. This case was heard on October the 18th of 2012. The vote was under our rules. The request for rehearing, a motion to grant a rehearing, have to come from one of the members in the affirmative. So in that, the vote was to deny the request. The vote was 4-2 to deny. The votes to deny come from Mr. Ewing, Mr. Garrett, Ms. Garrett, Mr. King, or Mr. Whitson. Voted to deny. Those that voted against the denial were Ms. Jones and Mr. Taylor. So Mr. Taylor cannot make a motion in this, but he can certainly act upon once one's made if you feel there's enough evidence here.
I now remember why I don't remember this.
And Mr.
'cause
Harper,
I wasn't
you
here.
were not here. So in this regard, Mr. Harper cannot participate in this vote.
so they
between
need
you
4 votes then, is what you're saying.
So I can't make the motion, but I could vote for the motion. Okay.
Okay, I would like to make the motion because I think this is a case that we definitely need to rehear. So I make a motion to rehear. Hopefully there's a second.
I'll second it.
Okay, got a motion, got a second. All in favor, say aye. Aye. I'm sorry, Dick, did you?
I'm willing to rehear.
Okay. So we have 4 in favor of rehearing or actually, I'm sorry.
And Mr. Harper cannot participate.
Okay, so 4 in favor.
Yeah, this is just a rehearing. We're not approving it right now.
That's
We're just,
correct.
they're coming back, and so they get to make the argument again.
And it's an all-new hearing.
Yes, it is.
Okay.
Just for the record, the board has voted to grant the request for a hearing. We'll set it for the next hearing, I believe it's December 6th. It's a brand-new case.
Look,
No, sir.
Testimony from the
Testimony from the prior case will not come forward. So this is, as the courts call it, a de novo case. It is all parties that are here when we get to that day and we start talking about announcements. I have to make reference to both sides, that we can't say, hey, in the last hearing I said, because it's a brand new case. Now, should they wish to submit into the record the same evidence they've turned in from last time, certainly they can do that, but it's not moved. I don't take the records from the prior case and slide it into this one. I'll assign a new case number to it. It'll be a whole new hearing.
As if it's never been heard. There'd be
It's as though it
opposition
has
or
not
whatever.
been heard. There's no erasing that it has been heard,
Okay.
obviously, from the human mind, but it's a new case as far as the standard of how you all hear it.
Mr. Chairman, just so that the board knows, the way this came about was quite by happenstance. I was, the day after the Board of Zoning Appeals meeting where this request was initially denied, I was at the planning department, and when we were discussing this case, when it came to light that the adjacent property, which is the state property that was the basis for the denial of this case, the planning department told me that it was in the works to rezone this to some other classification, likely a light industrial base zoning. The basis for the denial was because this state property is currently zoned residential, even though there are no residences on it. It was the denial was based upon the zoning of residential. The planning department told me that they are looking to rezone that property in the very near future to a light industrial use, which would then allow this use to be used at this location as a matter of right. When I learned of that, then I informed the applicant that they might have a basis for a rehearing, and that's why it's before you today.
And even though we don't get to subpoena people, I think it would be very helpful if planning, if they're listening, would come and give us evidence to that effect. I mean, it would be helpful.
Well, I had, and the applicant had requested the planning department provide you today with written verification, and they agreed to do that, and that's that email that you have before you, which supplies the basis of the new evidence for the basis for the rehearing.
So my question, if it is rezoned, there would be no need for a variance, correct?
That is correct, and that's why I thought this would be appropriate for rehearing, because if you're exactly correct, if it is rezoned, there is no need for a variance.
And how
They'll be
long does
allowed
that
to use the
process
site.
take? How long does that process take?
Well, that's really hard to say because there's a number of processes that are involved. There's the administrative end of it, then it would have to go to the Planning Commission for approval, and from there it'd have to go to Metro Council for approval. So there's a process. The Planning Department seems to think, or at least in the email they said that they thought that they would have that process initiated within the next 6 months, and then it would probably take another couple of months to get it finalized.
And so I know from their perspective, I mean, they have employees and want to run a business, and timing was kind of important to them, to the applicant. But I also understood just from looking at the rehearing and thinking about the length of the process that we do have the ability, and hypothetically, we haven't heard the case, but we can provide a timeline for a variance to say, hey, this is a 2-year or a 1 year or a 6-month variance to let you do what you need to do until this happens. And if it happens, then you're good to go. If it doesn't happen, then you need to come back and see us.
That's exactly correct. You can, and I would suggest that you consider that, to impose a condition, which you certainly can do, for a time frame by which this rezoning needs to take place.
Okay.
And let's, I guess, be clear about what's happening and what should not happen at this property. The property still, we did not approve this at the last meeting, so there should be no recycling activity going on right there right now, correct?
That is correct, and I've been assured that there is none happening at this site now.
So, Joey, you want to move us on to the rules?
Next item, adoption of new rules. Members, before you've been provided a copy of the rules, the changes that we made to the rules were cosmetic in nature, and I'd like to go over a few of those, talk with you about the changes that did occur. The first change that we made was in number 7. This is our procedural area. It spells out where we hold our meetings. Our old rules that we adopted in 2008 stated that we hold our meetings at 1417 Murfreesboro Pike. That was the Southeast, Metro Southeast building where we used to hold our meetings until the new Sunny West Conference Center was constructed. So that change has been made in your rules to reflect the current location. Mr. Chairman, actually, the board does have subpoena power. We can subpoena governmental witnesses, so with 5 days' notice, actually. And we've done that one time in my history here. Members, the next changes that I made, if you're familiar, we had a case. This deals with the need and special exceptions to have neighborhood meetings in a geographically close to the subject case before you, a neighborhood meeting on special exception cases, okay? And the board had in their rules the verbiage, and I apologize for not putting numbers on these. This will be, if you'll see Rule 10, this is just the line item above Rule 10. If you'll recall, our rules stated basically that if you did not hold that meeting, your case may be deferred, okay? We actually had a case go to court, and the chancellor in the case said that may is actually not may, it should be shall, and remanded a case back to us because the special exception applicant did not hold their neighborhood meeting. I've changed the rule to reflect shall instead of may. I had a really lovely typographical error on page 10 where I decided to duplicate Rule 7 twice. We pulled that off. The entry of the orders, this is where I label chair and vice chair. The old rules talked about chairman and chairperson. We have operated under calling the chairman or chairperson the chair, and the second being vice chair. Just fix that. The 2 other changes were dealing with the election of officers. You had 2 things on there that after each yearly election, the rules have to be ratified and approved. They do not. They have to be ratified when we adopt rules. But annually, we're not required to continue to go, yes, we like those rules, we like those rules. If you feel that you can make changes to these rules, the procedure spelled out in our rules. The second is that the board has to confirm, not me personally, but the zoning examination chief as your secretary. That requirement is actually written in the job description, which I hold. So the board doesn't need to confirm it. It's actually in the job description under the civil service rules that the zoning examination chief is the board's secretary. So there's no need for you all to to confirm that, you're stuck with me. So, and those are the only changes I've made to this document. We last adopted this March 10th, 2008. It was time to freshen them up. Things have seemed to flow fairly well since we adopted these rules. I don't know, Mr. Ewing, you've been on here, 8 years now? Close to it. We had some long hearings. The time constraints that we put on folks has really helped. There were days that we went 8-9 hours in these meetings, and there's really no need for that. But do you all have any questions of me?
Joey, are there anything that we need to look at these rules or change related to technology, faxing, email, scanning, anything like that?
We really did a good job in the 08 updates that I made to talk about submission of plans electronically by PDF. I did make one minor change. I had a DWG reference to CAD drawings. The program that I used to view that, we've lost. No longer have when we upgraded computers, I lost that software. So PDFs are preferred. We would really like to continue automating this process and eliminating paper. I would like to get to you guys, one of my goals for next year is to get my deliveries I make to you on Mondays, electronic submittals to you. So we're saving gas, and I'm not having to drive out there. But the paper, too, that we're going to turn around and you give me back that I'm recycling. So we'll do all that electronically. I'm trying to find a good software package that I can send you through email and not clog up our mail servers here. We've got a size limit on packets we can send out. So what I may look at doing in our website design updates that are coming in December for all of Nashville.gov is maybe creating a login for you all by password that you can go to the website, type in, and see all these documents that I'd normally send you.
I'm not exactly sure if it's our rules or if it's a matter of code, but oftentimes when we show up to the meeting, there's new information, usually from Metro, somewhere within Metro, but there's also, additional letters of support. Or is there no way, especially if you're going to start sending this all at once, is the rules the appropriate place to address that issue of,
One of our former commission members of a Surface, that was her big pet peeve, that, we'd get here and there'd be this stack of papers, and that how would we be expected to review something that was just put on our
Surface
desk?
went so far as, if you recall, folks were bringing entire binders to you the day of the hearing, and there was no way in the world you guys could read that. And that's why in these rules we set up this in 2008 when we did that, of, hey, have it in by Monday, the week of the hearing, to give those board members time. You even went so far in your rules to say, hey, we can choose not to accept it if it's just too bulky or large. I think you all were comfortable with, an email here or a single-page document. You were okay with up until a day, but you did not want somebody
A letter of support, here's an extra
and they go here.
Yeah, it's all okay. I mean, a letter here and a letter there is fine. Yeah. It's just when there's one of those days where there's a bunch of them, or that combined with a packet, then, it gets if we decide not to hear it, out of deference for the people that have come down to support or be in opposition to it, then we've got that pressure on us that, doesn't really seem fair to, on those folks. So
I can tell you from a practical standpoint, it's worked. Pretty much all the parties, even your neighborhood groups, are really good about getting us information on Monday, or at the latest it's Tuesday, and sometimes I'll shoot you an email, hey, here's something. The applicants will really encourage them not to deviate from the site plan they're showing to you up until the week of the hearing, the week prior to the hearing, I mean. So you don't come in and you've seen a site plan in your packet, and then you come in that day and it's a completely different drawing. Than's had there. We've had that one exception in the past where they basically flipped where the building sat on the lot. It was on the left side of the lot, and they moved it to the right side of the lot. The problem in that was the Planning Commission staff person who wrote their staff report based on it sitting on the left side of the lot. So I had actually called her and said, hey, could you come over?
But we do have a mechanism. I mean, we can just say,
yeah, absolutely.
We're not
you can say, hey, you can choose to defer the case on that. So,
Joey, one of my biggest pet peeves, and we're talking about written rules, but as far as I know, this is the biggest unwritten rule that we seem to follow every meeting, that there's nowhere in these rules that talks about if you're an applicant and if you don't speak in the first part, that you cannot speak in rebuttal. Tell us about that, and why are you have to introduce yourself for the record?
Well, I think the idea is that you don't want, the whole point of that sort of not a rule per se, but the whole point of that, you didn't have somebody come up on rebuttal and just bring up completely new evidence that haven't even been talked about.
But that's not in our rules.
Well,
I mean,
right,
we all
it's not
act like, well, you have to do it, and you have to.
It's really sort of, I'm not even sure, I hadn't read Robert's Rules in years, whether it's in there. That is our backup if we don't have it here. But the idea is that sort of the idea, you don't want to bring up new evidence because the opposition is really, they get one shot to talk to you. They don't get a rebuttal. So the idea is that person at least needs to be introduced and say, hey, I'm here to speak about any kind of traffic issues or something. That puts the opposition on notice that that guy that's just been introduced to you is a traffic engineer. That might deal with my argument that I'm about to bring to you.
So can we blame Robert's Rules of Order and our former Nashvilleian? True story, the guy that wrote Robert's Rules of Order lived here for about 4 years in the 1880s before he wrote Robert's Rules of Order and was head of the Corps of Engineers. True story.
That's his first name was at least Robert, or it could have been the last name, I'm not sure, but it's just sort of a policy. I've been here going on 16 years now, and we've always had that sort of.
Well, I guess the bigger question I pose it to all of you: do we want that in the rules?
I think it's fundamental fairness. I mean, for what Joey's saying.
That's sort of where we're coming from. It's a fairness issue of. It's really for the opposition that since they only get one chance to talk to you, we're not pulling something out. The applicant's not pulling something out of the bag that both parties really didn't contemplate. It's sort of that gotcha. So I think it's important that you all maintain that. So the appellants know I can't just bring this mystery witness up, out of the blue. And I think that's.
Well, I think it's about the only rule that I've ever asked you about before that I wasn't sure if we needed to put it in or if we should put it in. And obviously, if no one wants to put it in, I mean that's.
It could be that great unwritten rule that we follow more like just etiquette or.
I would say it's really more of a meeting.
John
kind
Michael,
of convention.
what's your take on this?
I would encourage the board to consider it a regular and prudent practice more than a policy or rule, because words like policies and rules make their way into challenges in Chancery Court sometimes. But I do think that for the reasons that Joey has laid out, there is great prudence in the practice. And certainly all of our boards and commissions would have manners of handling their various hearings or presentations before those boards in a way that's particularly expedient for whatever subject matter they typically hear. For you, this seems to have worked for just the reasons that Joey has laid out.
Very well. I mean, for example, the other thing, there's nothing in here that if we had someone disrupting the meeting, there's nothing here that says I can have them removed. But I assure you, I will have them removed from this meeting. It's more of as John Michael said, more of a practice or a policy. Standpoint. And just one other thing too, security for our meetings, I think we're about the only board or commission that has this, and I can presume, I hope I can speak, you all are very comfortable with our security procedures of wanding folks and going through the magnetometer that come in here, and some folks ask me why this board makes decisions that are sometimes final. The Planning Commission may make a recommendation to a city council that ultimately makes things final, but this board, many times, your actions are it for the person before you, and
whether someone can build or not, or
continue their business or not, or even for the opposition side, it's their only chance to stop something. So sometimes emotions can get up and heated. We hadn't had a very heated meeting in many years, but there was some rashes in the state of violence at some meetings. So if you are fine with this, I'm fine with continuing this on as well.
I usually have our attorney start my car for me after the meetings. He's not even listening. It was completely wasted on him.
Robert's Rules, aren't there different editions of Robert's Rules? Like it's been amended over time. Should we just add the clause in there, the latest edition of Robert's Rules?
We actually have
I think there's a Robert's Rules for Dummies.
the version I have listed in the absence of the rule is the latest version, which I currently have. So the revised rules of order is the current version thereof. They actually have a website now. You can still get a paper copy, but they.
Is there any merit to altering the special exception permit requirement for notifying neighbors within 300 feet? Is there any merit to increasing that distance? Because of some of the impact of some of these special exceptions can go beyond the 300 feet quite.
I would like to hear from our zoning administrator on that and that number and kind of why it's there and how it serves us through this process.
I think that number has kind of been a norm from what I've seen in private practice. And as a practical matter, and Joey, correct me if I'm wrong, but I think you've got a program already established where you can simply tell the computer and it tells you every parcel and every parcel owner within that. So it's set up as a program in our system already, and like I say, it's been my experience that 300 feet is kind of been a norm, and I assume it's a norm because it's probably been recognized by various courts over the years.
It is, and it's required by the zoning code, specifically laid out in our zoning code about how far we noticed based on that. The council can always change that.
Oh, so we couldn't even change it anyway?
We could not. I think we may have a problem if we said, hey, we want it to be 400 feet. There's an actual ordinance that says it shall be 300 feet, not 299.
But that's not to be construed as a limitation on how far away opposition can come from, is it?
That's true. No. And I tell you, courts have ruled in some cases. We had not to get too far down history, but we had a case where the residents of an adjoining county wanted to sue this board, and were arguing. One of their arguments was they didn't receive notice. Well, the court said you have no standing before this board anyway because you're not a resident of Davidson County. So I think there could be an argument made by this board if you're not a resident of this county. Certainly you shouldn't have a say, but that it's flowed very well. The council really chose to, in rezonings, we're talking about changes of area from agricultural to industrial. They have further areas, but I would think, Mr. King, barring the council choosing to do so, our notice provisions are just in line with what the council's adopted as far as.
Joey, I have a question about 7 section C2.
Okay.
At the boilerplate, how you start the meeting, you talk about various things, and one of the things you talk about is false and misleading testimony, and in our rules it just says false information. Should misleading be in there too, and why do we say misleading on the front end?
I'll tell you honestly, the front end portions were written by Mr. Shepard, who was before you earlier today, my predecessor in this job, and I'm honest with you, I haven't changed them. I'll sometimes ad lib from them. What I read at the beginning is not something I have to read at all. But I
think it's good that you read it.
I think, you all, to us, false and misleading all sort of run together. It's all about fairness. Are you telling the truth? These folks are not under oath.
Right.
I don't think there's any state statute that grants you such authority to do so. It is a quasi-judicial board, but it's not a court. Like we do have subpoena power, it says here, but there's no remedy if they don't come. So if I subpoena a government witness and he just says, I'm not coming, I can't go get the sheriff to go get him. So it's not that sort of thing. But for us, I don't have any problems, David. If I need to alter my opening remarks, I can do that too.
Okay, I would move adoption of the rules.
Second. As amended, or?
Yes, as amended.
As is before you.
Right, okay.
Okay, so move. We've got a second. All in favor?
Aye.
Any opposed? Great. I think we are done.
Great job on that, Joey. Putting that
Thank you.
together.
With that, the Board of Zoning Appeals is adjourned, and I appreciate it. Thank you both.
All right. See you.